whatever.
Which one? Tell me when.
That's good.
Right there. Okay.
Do we have anything preliminary before she's brought down?
Not on behalf of Ms. Evans, Your Honor.
No, sir.
How many individuals are planning on calling today?
Excuse me, Your Honor.
How many individuals do you plan on calling? Is there any other people want to speak on behalf?
Maybe one.
Okay. All right, take all the time you need. I mean, I just wanted to get an idea of where we're going. So who do we have in the gallery today?
Wow, we've got a army of people here for Deja Evans. Her mom, Dawn Evans, is here.
Good morning.
I tried to integrate
Is this on the record? Okay.
saying it, but I couldn't remember everything.
Whenever I start the case.
Diane, I watched it, they should grow up.
Oh, okay.
Sister.
Okay, another. Yeah.
I'm her best friend Corey. I'm coming from Japan.
Oh.
You came in all the way from Japan?
Yes, I'm stationed in Japan, Your Honor.
Thank you for
Who is?
Yeah.
Where?
Okinawa. I'm an Army engineer officer, captain.
My daughter just left.
Oh, she'll love it.
Yakuza. After 2.5 years, she flew out on October 18th. She was promoted Deputy Judge Evans to the 3rd Fleet, San Diego, for the next 3 years. So thank you for your service.
Oh, thanks for your support.
Appreciate you being here. And she's been back since October 18th.
That's awesome.
The unfortunate thing is, my mom and I didn't get to go to Japan because
Same,
COVID.
same. My
of
family
COVID. But anyway, they got my attention when you said that. And again, thanks for all you're doing.
Thanks for your support, sir.
I'm a mother.
Cousin,
I'm just a friend.
friend.
I'm an uncle.
Hey, good to see you. 4th grade teacher.
I'm Rhonda Twitty, I'm fourth grade teacher. Wow. I'm her aunt. Good friend. I'm a friend. All right. Mentor.
Then we have Tyra Patterson, her mentor.
All right, you have a gentleman over here.
Well, Angel, just old classmate from high school.
Thank you for coming.
So I had an opportunity to read through everything that was filed, even the supplemental information you gave to me this morning. I had an opportunity to read through it. I read through her transcript of her time while at the Department of Corrections. So, of course, I want to talk about that when she comes in.
Sure.
Other than that, floor is yours.
Okay. And I apologize for just getting that memo to you, supplemental one yesterday. My schedule is just blown up with cases all over the place, including out of state. Did my best to make sure I got it to Mr. Tolbert as soon as I finished it.
Sorry.
Second.
She's going to sit with her counsel. Can you put those in the front?
I sure will, sir.
I was gonna ask the same thing, Judge.
All right, so this is case number B05. Is that right?
Yes, sir, it's case B 1405219C.
Thank you. State of Ohio versus Deja Evans. That's what it's about.
I thought so.
All right, representing the state this morning
Stephen Tolbert.
and on behalf of the defendant.
Good morning, Your Honor. David Singleton for Deja Evans.
All right, good morning. Good morning, Ms. Evans. You can take your mask off if you would like. We are here on a petition for judicial release today. Again, I've had the opportunity to read all of the documents submitted to me. At this time, I'm going to hear from the defendant. If you want to come to the podium, that would be great.
Thank you, Your
If
Honor.
you need the podium over here, you can grab that as well. Or
I think I will grab the podium.
So I just want to start off by saying this, although not an unusual request, but this is going to be, I guess, a difficult position for the court to be in, because this was an agreed plea where the defendant agreed to a 10-year sentence. Is that correct?
That is correct, Your Honor.
In that 10-year sentence, there were 2 mandatory 3-year specifications to run consecutively.
Mhm.
So that was a mandatory 6 years.
That's
Then
right.
there was a 4th, I guess, specification that was not to run consecutively, but concurrently with the 2 other specifications. So there were actually 4 specifications, correct?
That's correct, Your Honor.
So instead of running all 4 consecutively, they ran 2 consecutive and 2 concurrent to come to 6, correct?
Your Honor, I believe the way Ohio law reads on those firearm specifications is that it's 1 specification per occurrence. These were 2 occurrences that had happened about an hour apart. And while it would be proper to convict or plead to 2 out of 1 event, there could only be 1 sentence. I believe on behalf of the state that the most she could have received out of either event was the 3 years.
Okay.
By law, they would have had to run concurrently with each other. So the 6 years mandatory that she served, I believe, was the appropriate time that was imposed by the court.
And then there was the actual sentence, which was the 4 years concurrent on all 4 charges, which gave me a total of 10 years, correct?
That's right.
All right. And this was an agreed plea, correct?
It was.
All right. You may proceed.
And because it's an agreed plea, the state is taking the position in this case that Deja must serve the 10-year sentence. Because basically the state's argument is that there was a contract between the state and Deja where she acknowledged in the plea agreement that she'd be ineligible for any form of early release. So here's what I have to say to the state. The state is going to stand on this contract, then that contract needs to be airtight and it needs to be precise in terms of the language in it. And our argument this morning is that the language that purports to render Deja ineligible for judicial release is a legal nullity. And let me just walk back and talk about how we get there. And I understand that the court has read the supplemental memorandum, but I want to be clear for the record what our position is. In Ohio, contract principles apply to plea agreements. And one of those principles, and this is really critical to Deja's argument this morning, is that plea agreements are construed strictly against the state in favor of the defendant. And what that means is that any ambiguities in a plea agreement must be resolved in favor of the defendant. And one of the reasons why that principle is one that is recognized under Ohio law is because where there are parties to an agreement, parties that have unequal, where one party has substantially more bargaining power than the other, then it's only fair and right and just to apply that principle of resolving the agreement in favor of the person with less bargaining power. And that person in this case is Deja Evans. When Deja entered into the plea agreement in this case, she was faced with a 16-count indictment. And 8 of those charges, half of those charges, were F1s, where had she gotten convicted at trial, those alone would have meant 88 years behind bars, not even counting the other charges and the specs. And so she basically was in the position where she had substantially less power than the state was represented by Gus Leon.
So what you're telling me is that she was faced with a decision: go to trial, face 88 years, or take whatever the state was offering at that time.
Take it or leave it.
Okay, go ahead.
It was a take it or leave it. And she didn't have bargaining power. And so that is what gets us to this principle of strictly construing the plea agreement against the state. So let's turn to what that language is. The plea agreement, which is in this intro-withdrawing plea of not guilty and entering plea of guilty, it says, I understand that by entering an agreed plea and sentence that I will not be eligible for any early release, such as transitional control program, intensive program prison, which I have no idea what that is, or judicial release or boot camp. So the state says that's the language that binds Deja. Well, the problem with the state's argument is that eligibility for judicial release is not governed by this document. It's governed by Ohio Revised Code 2929.20, which is very clear. 2929.20 A1A defines eligible offender as any person who on or after April 7th, 2009 is serving a state prison term that includes one or more non-mandatory sentences. And then the subsection that follows, subsection A1B, states that an eligible offender does not include any person who on or after April 7th, 2009 is serving a stated prison term for any of the following criminal offenses that was a felony and was committed while a person held public office. So Deja, under the terms of the statute, is an eligible offender for judicial release. And she's not ineligible under the statute because she's never held public office, right? And she also didn't commit the prohibited offenses that would make someone ineligible. So that is certainly one way to look at eligibility here. In fact, we would say that is the only way to look at who is eligible for judicial release in the state of Ohio, not what's in this agreement. Now, maybe what the state meant, maybe what they meant was to bind Deja in terms of having her agree not to seek judicial release. But that's not what this agreement says. It doesn't say that. It says I understand I'm ineligible. Well, that's, as I just walked through, is not the law in the state of Ohio. What the, what this language could have said, and I honestly, I try and figure out some argument probably, but I'd be basically out of luck. If what this agreement said was, I understand and I agree that I am not going to apply for, move for judicial release. Game, set, match, if that was what the language was, in terms of my ability this morning to argue that that wasn't binding. That's not what it says.
Right.
And so, given that the language in the existing agreement basically says something that is not true as a matter of law, that Deja is ineligible, that's ambiguous at the very least. And the way the court should interpret that is against the state and in favor of Deja. And what that means in this case is that it doesn't bind her. It doesn't bind her. The other point I want to make.
Well, let's stay at that point. I mean, because that is critical to our criminal justice process. You
Yes.
know, having to uphold these plea agreements.
Yes.
When individuals enter into these plea agreements, you know, they're coming to the court saying, you know, this is what I'm agreeing to.
Yes.
And the state is saying, we're going to give you this plea arrangement, but because we're giving this plea arrangement, you cannot seek. Well, that's not what the language says, right?
Right.
But that's
Right.
the intent of the contract between the state and the defendant, is that we're giving you this sentence that would be less than you would get had you gone to trial. In exchange, basically you agree not to seek this judicial release. And we're telling the court, please don't allow her for this judicial release because she entered into this agreement. And we have these plea agreements, you know, every day. So now you're asking me to go back and review the arrangement that she made, correct? And then just change it, saying that she made a bad agreement, and now let's change it. That's not what you're saying?
No, that's
Okay.
not what I'm saying.
Okay.
What I'm saying, and first of all, let me say this. The intent is not enough because they had unequal bargaining position. Here's Deja in my left hand, here's the state.
We always know that. The state
And
has the
that's-
greater bargaining power.
They gotta, and what flows from that is not upholding the intent of the agreement, but what is the agreement actually say? And if it's unclear what it means, you got to resolve that in favor of Deja. That is the argument that I'm making. Not because I agree that the intent may have been to at least on the part of the state to bind her so that she doesn't seek judicial release, but that's not what the language says.
Right.
So that's the difference between the way that you just formulated it and what I'm trying to convey. And if I'm not being clear.
No, I'm just challenging you on this because what we do today will have implications beyond her case. You know, one, they're going to change the language of that agreement. Would you agree with me?
They
on that?
should.
Right.
It should get changed.
And two, the state may be a little hesitant to give out plea deals if the judge is not going to honor those plea deals.
I don't know that the second point necessarily follows, but they should change the agreement and they should make it reflect what it is they actually intend and remove this ambiguity from it.
Okay.
And I am not asking you to change the agreement. I'm asking you to strictly construe it against the state as the law says you should. That's all that we're asking for. And I realize that that could have implications for other people in Deja's situation. But the other thing I would say is just because we're asking, and obviously we want you to grant judicial release here, you got the I mean, I don't want you to say no, but this is a decision you get to make in your discretion if we get past the hurdle of the language of the agreement. And so I don't foresee a situation where just because this faulty language, other people may try and say, well, I should get judicial release, doesn't mean that the court's going to grant it.
I understand.
The one other point I wanted to make before moving on to the merits of the judicial release motion is that there is nothing in either the entry withdrawing not guilty plea and entering plea guilty or the judgment entry that restricts the power of the court to grant judicial release in this case. The entry withdrawing not guilty plea and entering plea guilty is silent as to what the court will or will not do. It's all focused on what is in the agreement between the state and Deja. And then the judgment entry is just silent. It does not say that the court, pursuant to this agreed sentence, is not going to consider judicial release. And I realize, Judge Triggs, you weren't the judge at the time of this agreement, but Judge Metz, he could have done what Judge Kubicki did in that case where I included as an exhibit a judgment entry where it was an agreed sentence, and Judge Kubicki included in that judgment entry that the person would not be getting any form of judicial early release, including judicial release, as part of the agreed sentence. That doesn't appear here. So not only is Deja not bound by that language that we've been talking about, it's in the entry withdrawing plea of not guilty and entering plea of guilty, but this court has the power to grant the motion. And so the last part of my argument is why the court should use its discretion. And we recognize you've got wide discretion here. I want to focus on why you should grant this motion. And where I want to start with it is in September of 2014, this young woman right here had words sent to her from her father that no daughter should ever hear anybody say, let alone their father say. Go find the tallest building and jump off of it and kill yourself. I couldn't imagine ever thinking anything like that with regard to my daughter. That was said to her. And Deja had struggled with mental health issues before then. There was an incident, and I can give you the records if you want to see them, and I can give Mr. Tolbert a copy. But there was an incident in December of 2013 where she tried to take her life. And I'm sorry for putting your business out there, Deja, but this needs to get said. And on top of that, then she gets this text from her father in September. And that sent her back to the emergency room because she tried to kill herself when she heard that. And at that point, her life started spiraling out of control. And that's when she did something that was, and I don't want to say a mistake, because when you participate in aggravated robbery,
I appreciate that. Because
that ain't a mistake.
I get that all the time when people say it's a mistake. I know it's not a mistake.
No, it was crime. It was serious crime. Felony 1 level crime. Luckily, nobody was killed or hurt. But that was a result of the spiraling out of control and not thinking things through, and basically having, I won't use the actual word, and not that this is what she would describe it, but it basically was an epic moment in her mind. She was feeling unloved by her father. She had low self-esteem. She had just tried to kill herself a week before, and there she finds herself. Participating in a robbery, serving, going in and casing a Circle K, and then driving over to Clifton. Now, she didn't want to be part of what happened in Clifton with the robberies of the UC students. She didn't want to be part of that. But she was there, and she drove her co-defendants there. And so she got paid a price for that, and she pled guilty to that. But I wanted to just point that out because this is not who Deja Evans is. It's just not. She had never been in trouble before. She was enrolled at the University of Cincinnati in her first year. And it's not who she is. This was her worst moment, that period of time, from the time she got that text from her father till that night at the Circle K and then in Clifton. So Deja, sometimes this happens with people who go to prison. They realize that in some ways prison is a blessing in disguise. And I think that turned out to be the case for Deja, because she had an epiphany. The epiphany was that she's got to focus on her mental health, not just when she is in crisis and feeling suicidal, but every day, that she has got to be attuned to her health, that she needs to get into therapy and participate in that regularly. And if medication needs to be given, to take medication, she needs to prioritize that, because that's the way to make sure nothing like this ever happens again. I don't believe that it will. I'm confident of that. But the way to ensure that for Deja is to get the help that she needs. Her record at Dayton Correctional Institution, there were times she got into some trouble, nothing really serious. She worked her way down recently to level 1, which is minimum security. She has taken programming of attached certificates to her judicial release motion. She's very proud of this because she sent me an email on Friday when she went to go check her grades at Sinclair Community College. Straight A's. That speaks to her ability to shine in this community. So you've met, I think, you've met many family and supporters who are here and are part of the community that will embrace Deja if you grant this motion. Her mom is the rock. Is that fair to say? I didn't mean to make you cry. She's Deja's rock, and she has arranged for her to get therapy in the community. The therapist is named Tiffany Rush. She's a certified trauma focus, and that's important because Deja has seen her fair share of trauma. Trauma focused cognitive behavioral therapist, and it is Dawn Evans, Deja's mother, who would make sure that she attended her therapy, and eventually the goal would be to do family therapy, not just with Deja, but with Deja's mom and Deja's brother, because they've all been wounded to a certain extent. Her uncle Rick Powell, who's here, has a lot of connections that would help with employment. That's something else that OJPC helps people with when they get released, is to make sure that they are gainfully employed, and we would do everything we could to make sure that happened. Tyra Patterson has walked the walk in ways that are just profound after spending 26 years locked up in prison for something she didn't do, but that's beside the point. She knows what it's like to come home and have to get on your feet and thrive. And Deja and Tyra overlapped a bit at the Dayton Correctional Institution. Tyra has agreed to mentor her, to be a resource for her. And I frankly could think of no better person to play that role than Tyra Patterson. I just want to say this as I get ready to sit down. Steve knows that I respect him. We work together on lots of cases to free people. And I understand the position that he's taking and why he's taking it, or why the state's taking it. But what I would say to the state is, if they are going to insist that agreed sentences mean what they say and preclude people like Deja from applying for judicial release, then they need to get the language right. It needs to be precise, because that language should be and must be construed strictly against the state. That language that purports to make Deja ineligible for judicial release, when in fact the legislature said she is eligible, is a legal nullity. That's how we would ask the court to interpret that language. Judge Triggs, you have the power to grant this motion, and for the reasons that I've explained, I ask you to grant it.
I do have a few questions for
Sure.
you. So let's go back in time and talk about the two incidents. Let's talk about the first one, Ms. Evans' responsibility in that first one, and then the second one, and her responsibility in that second one.
Yeah, Deja definitely was involved in the first. What her involvement was she went in and cased the Circle K. Is that fair to say? She went in and she checked it out, and then one of her co-defendants went in with a gun and robbed the store.
All right, at any time during that first incident, did she carry a weapon?
She did not.
All right. At any time in that first incident, did she have any contact with any of the victims other than walking through the store?
Nope, she did not.
Did she ever go back into the store after the store was robbed?
No, not to my knowledge.
And how many other individuals went into the Circle K?
I think I'd have to look back at the recitation of the facts in the plea. I think both of the co-defendants went in. I believe that's the case. What was just one? I stand corrected. It was just one.
How much was taken? Do you know?
I don't remember, Judge. I can find
If
out.
not, I'll get it from the prosecutor.
Okay.
And maybe Ms. Evans can shed some light on
Yeah,
that night.
I'm
as
not
well.
sure that was actually mentioned in the. I will look back through this and see if I can answer that.
Okay. Then the second incident was not planned, correct?
It was not planned. They were driving back over to the Clifton area, and then the two co-defendants saw some people walking and said that they wanted to rob them. Deja didn't want to. She didn't get out of the car. She didn't assist. She didn't have a gun, and she remained in the area. I think she got out of the car at one point after one of the co-defendants had dropped something, and she went to pick it up. And there were, fortunately for the victims in this case, there were some plainclothes police officers in the area, and they arrested her immediately. But she was not, didn't have a gun, wasn't actively trying to assist them, but drove them over there.
And no one was injured.
That's my understanding.
Basically,
That's my exact.
her involvement was being there with these two individuals. One casing the Circle K, the second one was just her presence was there.
Yeah, I think the state would take the position that she had a more active role in the second instance. She drove them over there.
Right. So tell me this, she received basically a 10-year sentence
Yes.
for her involvement in all of this. What did the other two individuals receive?
Oh, gosh. Pompey, I think he got an 18, was it 18?
I know for sure
If you don't know, I know, I'm just putting it on the record. Well, one received an 18-year sentence and the other received 15 years.
Yeah,
I'm just trying to put
I
it
was
on
gonna
the
say
record.
14 or 15, but 15 and 18.
And how do you, what I want to ask is, do you think her sentence was fair in relation to what she did in these incidents compared to what the other two did?
Well, here's what I would say. I think that it was appropriate that she get less time. And that's significantly less time than the others. 10 years is a long sentence for someone who's never been in trouble before. I get it's a serious crime. I'm not trying to dispute that. Judge Singleton would not have given her, well, it wasn't up to Judge Singleton because, you know, it was the 10 years was what was worked out between the state and Miss Evans. But I think it was appropriate that she get less time than the other two. And basically that's what Gus Leon said on the record, was that her lesser involvement in the fact that she did not possess a gun at any time during the incident, in terms of physically possess it, that it was appropriate to give her less time.
You know, I have to think about what would I have done in that situation as the judge. Do I think a 10-year sentence justifies this crime? Now, I have the benefit of sentencing a lot of individuals, seeing a lot of crimes. And I'm going to challenge the state on this one because I've had far worse crimes receive less punishment on an agreed plea. And our system, I do believe, is broken. I mean, because we have individuals, give you an example, a couple of weeks ago, a rape charge only received 7 years on an agreed plea. We see these crimes get different punishments depending on the negotiating skills of the attorneys. So can you address that for me? I know you've been in this business for a long time, and I know you've seen those disparities. Can you address that? Because that weighs heavily on my decision.
I would say, Judge, that it's concerning. I've seen that play out repeatedly. And I personally think, I mean, that's why I was getting ready to say if I was Judge Singleton, I'm not a judge. I don't even play one on TV. But I think 10 years is harsh. And, you know, and it also depends on who the prosecutor is. I could be wrong about this. Knowing Steve the way I know Steve, I'm not sure that would have been his position. He's reasonable and fair. But that wasn't who the prosecutor was on this case. So I think it's the negotiating skills of whether the person who is charged has a lawyer who negotiates well. It is also, though, who the prosecutor is, and the luck of the draw went against Deja in that regard.
And the judge factors in as well.
Judge definitely factors in.
Right.
Judge definitely factors in.
We all would agree that definitely the prosecutor has the highest bargaining power. There is no doubt about that. Anything else you want to add?
Nothing else, Your Honor. We just hope that you will grant the motion and allow Deja to be home with her family for the holidays.
Do you want Ms. Evans
Oh,
to speak now,
I
or?
did want to say one thing, I just forgot, if that's okay.
That's fine.
It is my understanding that one of the victims, one of the UC victims, and I think this was represented in chambers last week, doesn't oppose release. I don't know if I'd say is supportive of release, but doesn't oppose it.
Right, we're gonna get to that in a moment.
Okay,
We
all right,
definitely will.
fair enough.
So do you want her to speak last, or do you want prosecutor to go now and then come back to, or she go now?
Let's have Deja go last.
Okay. Do you have any other individuals that's going to speak on her behalf, or does anyone else want to speak on her behalf at this point? If you want to, come on up.
Don, don't leave it on the field. It's okay. It's okay.
I'm going to tell you, everything weighs into my decision because it's very important that I know that she has family support. It's important that I know that she's going to get the mental health treatment that she needs, and that she will be a gainfully employed individual to contribute to our society.
I want to let her down again.
Tell me your name for the record.
Dawn Evans,
Go ahead.
she has my full support, and I wish I would have seen everything. All the red flags I saw and didn't act on when she needed help. It's too late now. But there's nothing I wouldn't do for her and our family unit, brother. If I didn't bring today, because I don't want to see his face. It just doesn't go away today. I don't think that there's anybody sitting there that wouldn't do anything for her to give her the support that she needs.
All right, so let's talk about living arrangements. Where would she live? And where is that? Is that here in Hamilton County, or is
Yes,
it?
it is.
I heard that she has employment opportunities. Is that correct?
She does.
And where would that be?
Her uncle is talking to some people that he knows that be willing to employ her. She's worked since she was 14. I don't have any doubt that she will continue.
And the mental health treatment, I heard information about that. Who was that with again?
Rush.
Tiffany.
Tiffany Rush, and she's already agreed to be her therapist, so we contacted through Tammy. She was already contacted to secure that and to make sure that we would have the right insurance in place. And she specializes in trauma. And there's so much more to this story than just what we're presented with today.
Feel free to tell me whatever you want to tell me.
I would be standing here all day telling you what I put her through and her father put her through, and just our transitions in life that resulted in what she's dealing with. And I take blame in some of that. I take a lot of blame in. I take a lot of blame in not being there when she needed me to be there, for seeing when she needed to be safe. I am committed to her. I've been committed to her through all of this. And I'm sorry for what she's done and what everybody's gone through over this. Her whole family went through this for her. It was hard on everybody, and nobody saw her going here. No one saw this for her. I'm such first time hearing that. But I could have stopped it and I could have helped it. And that's not easy to stand here and say, and I've dealt with that for years. I've thought about it for years. I've apologized to her for years for not being there when she needed me to be there. I just don't want to let her down again. So we'll go through it together. We'll be there together, the three of us, to get her what she needs and to get us where we need to be. I don't know how else to say it, but there's nothing I wouldn't do to make sure that she's okay. All of them. They're all there. They're all there. I don't know what else to add. I can't even think right now.
No
A
worries.
million
No-
words last night to say to you. 0 words right now.
At any time, if those words come to you, feel free to come back and talk to me. Okay?
Yes.
Okay. Thank you.
Your Honor, I believe Deja's uncle Rick Powell would like to address the court.
Good morning, sir.
Good morning.
Tell me your name for the record.
My name is Rick Powell,
Spell your last name.
Powell.
Thank you, sir.
I guess probably the most important thing that I can do for Deja is what I have been doing, and that is praying for her. The second thing that I can do is be a good steward of the resources that God has given me to help her and direct those in her direction. And I think that will manifest itself into 3 ways. One, Deja knows that she always has a safe place at our house. So does Dawn and their entire family. The second way, I think, is...
So tell me your relationship.
So my brother was married to Dawn.
Okay.
The second way is to help her find employment. I own a development company. We're prepared to give her an internship. So that's one opportunity. The 2 other opportunities are actually, I think, I'm more excited about, which is we have 2 nonprofits that are interested in speaking to Deja, and Deja can tell her story. And I think it's so much power in her being able to tell her story, not only for herself, but for other young women that will find themselves in this similar situation. We still have to make those connections, but both nonprofits know about Deja and are interested in having the conversations. One of the nonprofits, I was the past board chair, and they are completely supportive of Deja's case. And the third way is honestly financially. We're prepared to support her, my wife and I, financially, to help her get the therapy, help her get the additional education that she wants.
Okay.
Thank you.
May I speak?
Yes, ma'am. Come on up.
Hi, my name is Ariel Damasco.
One more time for the court reporter.
Ariel Damasco,
Spell your first name.
Arielle,
Last name.
Domascho.
Thank you.
I've known Deja my entire life. Her family and my family grew up. Her uncle and my father were the best of friends. It was knowing her. She is a light. She is a wonderful piece of light to know. She is going through her own thing, and I would message her something so minuscule as I got the wrong meal at a restaurant, and I would message her while she was in prison. And she would be like, oh my gosh, I'm so sorry, you had a horrible day. She's in prison without her family or anything like that. And I would message her, and she would still be there for me. And she was like, I'm so sorry you're dealing with this. Is there any way I could help? And she would offer advice, anything to make me feel better. I had my father walk out on me when I think I was like 20. He just left my life. So I understand where she's coming from. I've tried to kill myself. I have done things that I did not want to be in this world anymore, and done numerous things. So I understand where she's coming from. She has a mother that I wish I had. That woman right there she is something else. She will have her back. That girl is loved so much by her mom, and she's beautiful inside and out. She deserves this. She deserves to be with her mother again. She deserves it. She deserves everything. She deserves a fresh start. She deserves a second chance. She deserves a life after this. A life after all this depression, all this hurt that she has gotten. Saying her father telling her to go kill herself. I've been there. My dad would tell me hateful things, and I've tried it. I understand where she's coming from. She has a mother that she's beautiful as just as much as Deja is. This family it's beautiful. Her brother, she deserves it. She deserves to be free. She never deserved any of this. You never deserved any of it. I'm sorry. I love you. She deserves to be free, Judge. She will do right. You will never see her. I put my life on it. She will do right. She's good. She's good. She is a wonderful human being. You are. You are perfect. That's all I gotta say. She's in good hands, I promise. Thank you.
All right, thank you.
I love you.
And last one.
Hello,
Good morning.
I'm Tyra Patterson,
Spell your first name,
Tyra
last name.
Patterson, Patterson.
Thank you. Go ahead.
I do not know Ms. Evans, but I'm willing to be her mentor, along with OJPC, give her meaningful opportunities. Oftentimes, a lot of people don't understand the barriers that we are faced with.
Tell me, what is your position at OGPC?
I'm the community outreach strategist and a paralegal.
Okay.
So I am willing to take her up underneath my arms along with her family and make sure that she has the right resources, because oftentimes we don't have meaningful opportunities. And I understand that we face over 900 barriers. I am willing to walk through those barriers with you and for you. I don't know her, but I do trust that she will do the right thing with her second chance if you entrust us with her. Whatever her family needs, I'm able to be there and be a phone call away. Let me see. Anything that she needs.
So you mentioned those 900 barriers.
Yes.
Tell me some of those barriers that you foresee.
Well, some of them are just job opportunities. A lot of companies do not have the policies to hire people who have made mistakes. Some of them are banks. Like, there's things that she will have to navigate through and will become frustrated, as I have become frustrated, and I can help guide those routines for her. Because I do know personally what those barriers are. I will also be her mentor, but also give her other mentors that will hold her hand through the process, not just guide her, not just point out things, but I will walk with her.
I know it takes a lot to come out of an institution and reacclimate to society, especially when you've been away for a long time. I've seen the struggles. I've seen individuals come back time and time again. How do we prevent this for her?
I think therapy. Therapy is a big issue that is not offered to us. So when David and her mother had mentioned therapy, I think that was the most important thing that she could do for herself. And also have people who are directly impacted, because I understand personally, to be in her corner who is doing constructive things so that she can be a productive member of our community, which she will be. I can guarantee that.
Okay. Okay, great.
Thank you.
All right, thank you.
I think our fourth grade teacher just wants to say some brief remarks.
Come on up.
Okay.
All right, a couple more people want to say things.
This is your time. You have to convince me that she's worth being released today.
Hi, my name is Rhonda Twist.
Speak loud and clearly for me.
Rhonda Twitty.
All right. Do we know each other? All right, we need to disclose that just for the record.
We went to high school together.
Okay. Well, anybody who's anybody with the Lawn Hills, right?
On the hills. Deja was my fourth grade student. We have been close ever since then. To speak to her mental state, I know her mother spoke about how she takes on a lot of that responsibility, but I think as a system, we failed her. you don't just get to 18 or 19 and have mental issues. There was things along the way that we missed as a system. I just want to say that I think at this point, we have an opportunity to help her survive and to thrive the rest of her life and not let this be the end for her. So I'm hoping that you see it the way we see it, that she is worthy. She's worthy.
I see that she has the support, and that's key to being successful once being released. That's the biggest thing. I see so many people come back because they don't have that support. They don't have family that will take care of them when they know they have nothing coming out, or employment opportunities, because a lot of them can't get employment. So that's the key in keeping her out after release.
Yes, and I am also committed to reconnect with her after her release to as a support to her, because we have, she was my fourth grade student. They have always stayed connected to each other. So this is just, I haven't seen her since then. We connected through the rest of her elementary and her high school years and beyond. So I'm gonna continue that commitment with her.
All right, thank you. Thank you.
Good morning, Your Honor.
Good morning.
I'm Corey Jordan,
Spell your first name.
Korey.
Thank you.
Jordan. Your Honor, so I'm Deja's for around 10 years. Also, I'm a captain in the U.S. Army. And as an officer in the Army, we often have times where I have the authority to punish young soldiers. Deja was 19 when she committed this crime. And one thing that people always don't consider is the character of the person. Deja was prior to going to prison, she was an amazing person. She was a very active member in the community, always going to soup kitchens, volunteering at church. She's a churchgoer. I'm sure in prison she was a light for a lot of people, but she's also a light outside of prison. And she's always there for you. She's very dependable. And I would just it's been really hard not seeing my friend, since she's 19. As I'm going and progressing in my life, I've lived in Korea, lived in Japan, lived all over the States, and just seeing her held back. 19 years old is such a young age to just be held back for 10 years. I would really like to see her be free so she can go on and continue being a light and being an active member of the community again. Sorry.
I know you're good. Thank you.
I believe that's it.
All right, thank you. Yes, sir. Prosecutor, you're up.
Your Honor, I believe this is the first one of these Beyond Guilt Justice and Policy Center cases that I've had in this court, and I was assigned to this project by Joe Dieters, who wants to be an active participant in these cases and try to help out and go along with a second chance when we can. I think that we've been active and helpful in releasing several people over the last few years who otherwise might not have had the chance, had not the Ohio Justice and Policy Center through David Singleton filed the paperwork and pursued that on behalf of these clients. Ms. Patterson was one of the first, if not the first case in which I was involved to help her get released. And frankly, personally, there's nothing more that I would rather do at this point than to go along with this. But as the court correctly pointed out in the beginning, this was an agreed, negotiated plea. And the sentence that I believe comes into play here. When she signed off on this, she agreed that I will not be eligible for any early release. To me, the word any is fairly well understood. It's all encompassing and means any early release, obviously, regardless how it's phrased in a motion. Statutorily, at this point, I will concede she is eligible to be released. The statute does not preclude her because of an agreed sentence. What the state believes precludes her is the written agreement that she went into. Before she signed off on this, she had both the statutory and constitutional right to a jury trial, which she waived. She had a constitutional and statutory right to question and confront the witnesses against her, which she waived in exchange for, as Mr. Singleton correctly pointed out, had she been convicted and of all counts and all appropriate firearm specifications, she was probably looking at close to 90 years. The state agreed to 10. Now, the state does have a lot of weight when it comes to bargaining these sentences. But this was, an agreed upon sentence. The word any, I think, is clear, and therefore the state would ask the court to overrule this motion because back in March of 2015, she agreed that she would do a 10-year sentence, and that's going, for credit for time served and all, she's really isn't going to be eligible until September of 2024, and certainly I'm willing to answer any questions that the court would have.
I have several questions. So let's start with our plea agreement. We use this form every day. We have multiple plea arrangements every day. And that language is in every plea arrangement. And no one has ever challenged that language. It's someone actually giving up their statutory rights to apply for a judicial release. And no one has ever explained it to the defendant in that way. So are you telling me that now the state can take away someone's statutory rights by signing this document? You're asking somebody to give up their statutory rights. Is that correct?
Yes, the state, through the judicial process, takes away the rights of people every day. It's just to be done within the due process of law and be done fairly. But I mean, the state takes away rights of people every day.
Right.
It's part of the system. I mean, it is the system.
So, but are you telling me that the contract overrides the statute?
I think that when this was signed, the intent of both parties was that she would do 10 years.
Right.
And whether it overrides the statute, I guess I can't argue that it overrides the statute. Judge, I would concede right now, you have the statutory authority to grant this. The only thing that is preventing you, assuming you would find her an otherwise eligible candidate, the word any, I believe, is what prohibits you from doing this at this point. It's a fairly straightforward, simple word, and it encompasses all form of early release, which, however we want to call it, this is.
Would you agree with me that the state has the ultimate bargaining power?
It depends on the strength of the case.
Right.
The state, it depends. If someone is caught in the act and makes a full confession, Yeah, I'd say our bargaining power is pretty good. If it's, you know,
But,
some other
you know,
form,
in
maybe
in this situation, we have a 19-year-old who is faced with a 16-count indictment.
That's correct.
And the prosecutor goes to her and her attorney and says, if you take this to trial, you're looking at the better part of a century in prison, up to 90 years. Here's a 10-year deal, take it or leave it.
Yeah.
I mean, do you think that weighs heavily on her decision to say, I'm 19, do I
Yeah,
want to
I'm
spend,
29, or I'll spend the rest of my life.
right, or the rest of my life in prison? And
Well,
you-
I'm assuming the judge would go on. I mean, in all honesty, I mean, Judge Metz was not known for being a harsh sentencer, so I doubt seriously that realistically she was looking at 90 years, but she was probably looking at more than 10. I'll concede that.
Right. I mean, but the threat of 90 years,
Yeah, the threat was there.
the threat was there.
There's no question about that.
And now you have this 19-year-old having to make a life decision, knowing that she's guilty of something. She knew she was guilty of something. And she knew that at some point she was going to have to suffer the consequences.
Yes.
Her involvement in this, knowing what we know, I mean, because we've seen a lot of cases, is 10 years justified, in your opinion?
Well, I didn't negotiate that, and, you know, I mean, she participated, if you look at it from the harsh view of facts that the state can present, I mean, she participated in an armed robbery at two separate events, perhaps as many as 5 people, 3 in one incident, and 2 at the BP store. If you do 10 years divided by 5, I mean, you could argue, hey, that was only 2 years per victim who had a loaded, operable firearm pointed at them.
And I
Is 2
understand,
years all that bad?
I understand what the law says,
Right.
even though she did not have a firearm.
She did
because
not. She
Her
was not the one.
co-defendants,
She
had a
was not the one who
firearm.
carried the firearm.
basically, even though she didn't have it, her co-defendants had it, and because of the way our laws are written, they had it, which equates to she also having it. That's just the law, correct?
Correct.
All right, go ahead.
I mean, I'm just answering your questions at this point.
Well, I understand.
I've made the argument, I mean, you know, the argument of the state is that
You want me to uphold the agreement and every agreement that comes before me. I mean, because I probably do 10 agreements a week.
I'm not here to address every one. We'll do those one at a time.
I understand. I mean, but this will affect every agreement after
I mean,
this
I'm not,
case.
you know, I don't know that this does affect every agreement after, and maybe the state would still be willing to enter into agreed pleas, and maybe it would not. I mean, I think that it would behoove, you know, the trial attorneys that negotiate these pleas to maybe add language, there's written language at the end of this agreement that, you know, the defendant expressly waives any and all right to seek any form of early release. I mean, that would have made it,
But can they really do that? Can they really do that? Can they really change the statute? Can you force someone to give up their right in order to get this deal? I don't know. I mean, that's just going to be a question for our Supreme Court whenever it gets, you know, appealed to that level. Can someone actually be forced to give up their rights?
I believe that people give up rights all the time as long as it's done knowingly, intelligently, voluntarily. I believe
I
that
agree with you.
this right can be waived. Now, if you find that it was not allowed,
No, I mean, it's more than that. It's more than just the agreement itself. I mean, it's everything that plays into our judicial and our criminal justice system of how we come up with these plea arrangements, and whether or not, you know, Ms. Evans deserves a second chance at this point. And this is only about Ms. Evans. It's not
Correct.
about the other cases that will come before me.
I wanted to say that I don't think I mean, even though I represent the state, I also don't think it's fair to put the weight of the entire judicial system on her shoulders in this case. I mean, I would think that if the court is inclined to grant this, I would not want the reason to not do it is because of all the problems it could cause down the road. That's not her problem. I mean, my argument on this one case is she signed this piece of paper. Annie means Annie.
Have you had an opportunity to speak with any of the victims?
One.
One. And what was
His
his
name,
or her opinion?
He was of the opinion, I don't know exactly how he phrased it. He would not oppose this if he were here.
And he's not.
He lives in California.
Okay.
He was one of the 3 UC students. We were not able to find out where the other 2 are. Through him, we tried, and that did not prove to be successful.
All right.
The Circle K employees are long gone as well.
All right, thank you. Any other witnesses on behalf of the
Judge,
state?
I mean, I'm not, I don't know which way the court is going, and I'm not, I know these 2 documents are part of the official journal entries of the court, but with the court's permission, I would like to mark a copy of the entry withdrawing the plea of not guilty and plea of guilty as State's Exhibit number 1, and the sentence entry is State's Exhibit 2 for the purpose of this hearing, should it be necessary for the Court of Appeals to review this at some point.
Thank you, you can present it, but I'm looking at it on the screen.
I'm Judge, I know that I just didn't want someone coming back to me 6 months from now and say, why didn't you enter copies of the plea agreement in evidence?
Oh, trust me, I'm ready.
Right, I understand, I know you have, top one is Exhibit number 1, the bottom is Exhibit number 2.
Thank you. We'll take it to mark.
Ms. Evans will address the court, Your Honor, and before she does so, I just wanted to say, the critical word here is eligible, not in the. Thank you.
Hi there.
Good morning. Tell me your name for the record.
Deja Evans.
Go ahead.
They're nervous.
Take your time.
Okay. There are no words that I can find to express the remorse and guilt that I feel for inflicting the trauma on the victims in my case. And no sentence that they give me will carry out that. Like, I will carry that much longer than any sentence given to me.
How long have you been in?
7 years total.
Go ahead.
At 19, I was a people pleaser. I was struggling with a lot of things, and I really just wanted to fit in somewhere. And I didn't appreciate all the support that I have because I didn't know. And it wasn't until going to prison that I realized I had all these people. Prison has saved me, and I've been working on loving myself, finding my own self-worth, building my faith, and these are the things that I just want to continue to work on and pass to other people, younger girls who are struggling with the same things that I struggle with. I'm eager to attend therapy because I believe I need it more than anyone else. I think I need it.
So, I mean, I have a lot of questions, okay? Tell me, at 19, who were these individuals that you were with?
One of them was a friend since the 4th grade, and the other one was my boyfriend at the time.
Okay. And who came up with the idea to rob the Circle K?
My longtime friend.
And what made you at 19 decide this was a good idea?
I didn't think it through. I didn't. I just was going to be there for my friend. As I said, I was a people pleaser and extremely codependent. So I didn't think it through.
And then on the second occasion,
I did not want to do that.
so what happened on that one?
We were driving back to my other co-defendant's where he lives, and we have to go through Clifton, and the idea got brought up, and I specifically said that this was a terrible idea because there are police everywhere. I mean, I attended the school, so I got a text message every time something happened, and I was completely against it.
Did you do anything to try to stop it?
No, I didn't.
And you were the driver?
Yes.
Your car?
Yes.
So tell me about your time in prison. You know, I have everything from the day that you started there up until now. And we're going to address some of these issues and infractions that you had. Many, many infractions. So tell me what was going on in your mind during the last 7 years.
Well, I seem to always have an issue with authority, and this is actually a lesson that I've learned recently is, pick my battles, which is what I've been told for a long time, but it's been really settling into a lot recently. So I have a lot of disrespect issues during my time. It's really hard when they're talking to you a certain way and you have to bite your tongue, but eventually I got it.
So how long did it take in order for you to get it?
About 6 out of my 7 years.
I mean, there are a lot of infractions, a lot of disrespect towards the security guards, to the staff, a lot of just acting out, not wanting to be in uniform, not wanting to be where you're supposed to be at certain times. To go from where you were at 19, this mild-mannered, people pleaser, to what I see on paper is totally opposite. You went from being a people pleaser to being totally opposite, to disrespectful and not wanting to abide by the rules and regulations. So how do you explain that?
I can't. I was going through things at the times, and there's like time frames where it would be like really bad if you notice that. I can't. It was not an easy situation to be in, and to be talked to disrespectfully a lot. It's hard to bite your tongue. They don't treat you the best in there. I know a lot of things I did on my own. Those disrespect tickets, I can't. I'm learning still. I'm still learning.
So how are you going to be if you're released? I mean, are you going to go back to where you were at 19, or are you going to continue on the same path of disrespect?
No, not at all. I'm completely different from even those tickets.
Well, tell me that. I mean, you have to convince me that you deserve this opportunity.
I've just put in a lot of work for the past couple months.
Tell me about that work.
I've gotten so many books sent in and working on figuring out who I am, because at 26, I still don't know, especially when I've been in prison for all these years. So I've been working on workbooks and just reading and praying. That's all I've ever been able to do.
Tell me about school.
I was in Sinclair, and I took family and violence. I took a CPR that led into a personal training, and I took correctional case management.
All right, let's go back to when you decided to take the plea arrangement At 19, tell me, what were you thinking?
I honestly didn't even know what any of it meant. I didn't realize that that was a part of my plea agreement until I met with David and he showed the transcripts, because the lawyer that I had prior to David never made that clear. He even reached out to my family saying that I should be eligible soon. So I don't even think he realized. I mean, he knows, obviously, but I never knew that I was signing to do 10 years. I just was afraid and signed whatever my lawyer told me to sign.
You've been involved with drugs.
Yes.
What type of drugs?
Marijuana.
Is that the only one? Is that going to be an issue for you?
No. I'm afraid to violate any way, shape, or form. So
Anything else you want to say?
no, sir.
You sure this is your opportunity? Right now, I stand between the next 3 years of your life.
I just would like to stress that I have made a complete transformation in a very short amount of time, and I have realized a lot about myself that I didn't realize before. And I just really want to continue to work on them, and professionally and on my own journey.
You know, there are individuals who are watching you right now, and I want them to hear your story, because I have a 19-year-old, and I want to make sure that she does not fall into that same trap of having someone else dictate her life for her. My daughter's been in the courtroom her entire life. She's sat with me on this bench for the last 20 years. So she has seen some things, and I want her to see those things, because she knows who to get in the car with, who to deal with. She knows that she don't want to ride with certain individuals. I mean, she is the type of person that if it's not her way, then it's no way. And I want young women to feel confident in saying that to the men in their lives, that you are not worth me going to prison for. And that's what I want this type of situation to be for other young women, to realize that no man is worth going to prison for. And in this instance, you allow two individuals to put you in this position. So how do you respond to that to other individuals at 19? What would you say to them at this point, knowing what you've been through?
I think a lot of it comes with self-love, and I didn't at that time. I didn't value life at all. So I think that would be my biggest things for people to know their worth, because if I had known, like your daughter at this time, I wouldn't have made any of these decisions. I didn't value my life. If I was trying to take it, I wasn't thinking about it at all. I think it starts with self-love.
And what are you going to do if I give you this opportunity?
I want to tell my story and start younger than 19 with girls who are struggling with the same thing.
And I think it starts with what you said earlier, being that people pleaser. When you're a people pleaser, you can get talked into anything. Anything else?
Thank you.
All right, thank you. Singleton, final comments?
Your Honor, we're going to ask you to grant the motion. It's our position, you've got the power to do it. The agreement is not binding for the reasons that I went on and on and on and on about, and it's also in that memorandum, supplemental memorandum. And therapy will be a good thing for Deja. The kind of trauma-informed therapy that she needs, that her mom has arranged for, will make the difference in terms of keeping her on the right path and actually allowing her to shine. And Deja, just so you know, from the very beginning since I met her, she talked about how she wants to talk to young girls. She's not just saying that in response to your questions today. This is something she wants to do because she realizes she can be a voice. And we would ask you to set her free so she can be that voice and that beacon for young girls to avoid making the same mistake that she made. Or not mistake, crimes that she made.
Thank you.
Thank you.
All right. Yes, sir. Any final comment?
No, sir, I've said everything that I need to say at this point.
If you want to approach. Is that your turn? I mean, this is a very hard decision to make. On one hand, I have the state's interest in making our plea negotiation process fair, making it to the point where the state knows that their agreements will be upheld by the court. In this particular instance, I was not the sentencing judge. So what I'm relying on is all of the documentation that was submitted by you, going over the record, and making the determination to override the prosecutor, override the sentencing judge, and give Ms. Evans another opportunity. It's a hard decision because our justice system relies on the plea negotiating process every day. If individuals think that they can, enter in a plea, agree to something, and then later say, I don't like that agreement, I need to readjust, it breaks down our system. And then the prosecutor will no longer offer those plea arrangements if they think the judge is just going to change that arrangement several years down the road. But then individuals are faced with the situation of, do I take a chance on going to trial, getting 90 years, or do I sign up for the 10 years and try to get out a little bit early? So our system is flawed, I know that. The state does have extreme bargaining power when you're looking at decades in prison over this agreed upon sentence. And whether or not a person can give up that right to be an eligible offender, I believe you're probably the first one to actually bring up the error in our plea forms. Because the wording does take away someone's eligibility when the statute clearly makes them an eligible offender. And I know probably 10 times out of 10, the defendant does not read that form. They're just signing that form because that's what their attorney told them to do. And they think that they're getting the best deal possible. You know, going back in time, if I were the sentencing judge, I mean, do I think a 10-year sentence for this type of crime is justified? I can honestly say no. Because I know the type of deals that are given out. I've been a part of deals where I didn't agree with them, but those were the deals. And I went along with the deals because that's what the state and the defense attorney has worked out. Like I said, I've seen crimes that were far worse than this get a lot less time. I've seen where individuals who killed 3 people only got 7 years. And so do I think the sentence in this case justifies the crime? No. Do I think that she deserves an opportunity despite what she signed? I'm going to say yes. But here's a stipulation. You understand? I am very hard when it comes to granting these judicial releases. You will probably, no, I can say you will only be the second one that I've ever granted. I mean, I've looked at your history. I see that you've had some issues. And I know that there are some issues when you go to prison. I get it. I see it all the time. But I'm very hard and I'm very strict. You understand? If I grant you this opportunity, you have to abide by all of my terms and conditions. I mean down to a jaywalking ticket. I do not want to see it. You understand? You have to go to your counseling sessions. You have to gain employment. You understand? Stay out of trouble. I do not want to see any trouble. You understand? So at this time, I'm going to grant the motion for judicial release. She'll be on probation for a period of 5 years. I will remit fines and court costs, make a finding of indigency. She's to report to probation as soon as she is released from Dayton Correctional, which may not be until tomorrow or Friday, which means you would have to report to probation Monday morning.
Hopefully she'll be released from the jail. We'll work through the paperwork.
Okay. I know she has to go back to Dayton to be processed. You have to abide by all the terms and conditions of your probation officer. Remember that. Not one mess up or you go right back. You understand? You agree to those terms? All right. Good luck to you.
Thank you, Aaron.
Thank you.
Let me turn this off and I'll get it to you.
I think you're going for it. I think you're going for it.